Well, here now with reaction, James Trusty, a former federal prosecutor. James, really glad to have you with us today. Very interesting, even though both sides have rested their cases. Today, Friday, is a very interesting day in court because now you get to start to see how the different sides tip their hand a little bit in terms of how they feel about the case. What did you take away from what you saw today?
Yeah, I think that characterization is exactly right. I mean, this is a moment of high-stakes poker where the prosecution starts telling the judge, hey, we want some lesser includeds on the table because we're not feeling so great about our lead charges. And what was interesting is the judge seemed to signal that if the defense objected across the board to lesser includeds, he might have gone with that. So you might have had a situation where the defense says, we think it went so well that we want to stick to those lead charges. Big risk, but less risk of a compromised verdict, which is what lesser included offenses gives you as a prosecutor.
When you look at this, you heard Jonathan Turley say, look, this was just the prosecution overcharged this thing. And some people have said part of the reason for that is because of the public discourse that has happened over the past, year around this. And there was so much media focus on characterizing Rittenhouse a certain way. Do you think that that led to what the prosecution has done here potentially in terms of overcharging on the case?
I think, sad to say, probably. Look, when a prosecutor makes decisions, rushes to judgment based on the politics of the moment, of satiating the mob that is declaring that this kid is somehow a racist terrorist, that's a bad moment. I mean, he charged this case within 48 hours. And I think wherever you are on the nature of this evidence and how strong or not the evidence is, it certainly looks like something where prosecutors and investigators could have spent more time to take a rational approach at investigating this case instead of just immediately jumping out 2 days later and announcing these very significant life-eligible charges.
There's been a lot of conversation about a mistrial. We've seen the judge go after the prosecutor pretty hard on a few things. The question is, will that happen? When might that come out? Is that something that the judge kind of keeps in his back pocket depending on how things unfold? How do you read that?
Well, not always, but I think that's what's going on here. I mean, judges, no matter how strongly they feel about the case, they're loath to jump in and be what's called the 13th juror. They don't want to be the ones that take over the case and dismiss it or acquit after there's been a verdict of guilt. But in this case, sitting on that motion for a mistrial could be a very interesting play by this judge, where he basically says, let's let the jury run its course. If he doesn't like the case, that means he's waiting for them to acquit, at least on all the serious charges. And if they don't acquit, then that motion for mistrial becomes revisited as a motion for new trial. I mean, the area that the prosecutor stepped in is a third rail. When you talk about Fifth Amendment right to silence, that is a basic fundamental third rail you don't touch. He touched it, so this judge might be sitting on that information thinking, I've got a backstop if I don't like the way the verdict turns out.
There's been some criticism of the judge in the media and the way that he's conducted the trial. From your perspective, a lot of people on their hand would say, no, he's running a pretty tight ship there, and he's demanding that all the attorneys follow prescribed rules of justice and conduct in the courtroom. What's your take on that? Would you say he's running a good show there, or would you agree with some of that criticism?
Oh, I guess I land squarely somewhere in between. I mean, look, he's a little flamboyant. There's definitely times where he shows an awful lot of fire, a lot of emotion. He tends to take offense. But at the same time, he's been confronted with some moments that were pretty bad in terms of prosecutorial behavior. So I really don't begrudge him the fact that he called out a prosecutor for violating a previous order about the right to silence. That's fair game for a judge to get mad about. He's a character. He definitely likes to talk, definitely likes to opine on things. But look, the evidence is the evidence. I don't see him, manifestly affecting the case in a way where they haven't been able to present the evidence they want to present.
Yeah, the evidence is the evidence in an environment that seemed to be so driven by a media narrative around Rittenhouse. The evidence has been particularly interesting. James, we always appreciate your perspective. Thanks for joining us today.
Sure.